power to the Supreme Court itself to regulate its procedure, as has been done in the past, as has been held in a number of cases which we bring before your lordships. Those cases are well known.
Now I just ask a question. You can note it.
Ji.
Are you suggesting that that even the rules of 1980 are ultra vires the Constitution? Please let me finish. Because the power vests in the Supreme Court as all the judges of the Supreme Court. That could be one reading of your argument. So you are saying that Section 2 is the ultra vires of the Constitution, which gave power to 3 persons. Order 11 of the rules is ultra vires because it gave power to 1 person. Is that your proposition?
No, madam. My proposition is very straightforward. As far as the 1980 rules were concerned, they were made by a full court, which was at that time. The entire historical perspective has been given. My proposition is slightly different. These were under 191. It is the function of the Supreme Court itself to regulate its thing.
Okay.
See, 184.3 is not the only power.
Baja Sahab, you can later answer my question. So what you are saying is that the expression subject to the Constitution and law, this becomes redundant? That is the question. That is what you are interpreting it.
I'll answer that. We'll answer that. We noted, we'll answer this thing. But my basic question, why I came before your lordship, is that the functions which are there with the Supreme Court, there should not have been there with the Parliament. Because that institution that has its own. Today they say that how you are going to have the benches. Tomorrow they will say that such and such bench will hear this case, such and such bench will hear that case.
No, please let's not go into what they may or may not do.
Why I'm saying is this, that if I give them unbridled power, then anything can happen.
Raja Saab, it pertains to your attack on a particular piece of legislation.
I'll say this thing.
No. What Parliament decides to do future, you can bring another petition, we can look at it then. Restrict yourself to your case. Please proceed.
I will say this in the end, that this clause 2 is beyond the powers of the Parliament. Three, and when I'm arguing, my associate will explain that 184.3 is not the only thing which is regulated by the Supreme Court rules. If your lordship would have the 1980 Supreme Court rules in front of you, there are the different types of jurisdiction which are available to you.
Shall we finish with the Act quickly?
Oh, okay, I'll finish with the Act, my lord. Exercise of original jurisdiction of the Supreme Court. Any matter invoking exercise of original jurisdiction under Clause 3 of Article 184 of the Constitution shall be first placed before the committee constituted under Section 2 for examination, and if the committee is of the view that a question of public importance with reference to enforcement of any of the fundamental rights conferred by Section 1 of Part 2 of the Constitution is involved, it shall constitute a bench comprising not less than 3 judges of the Supreme Court of Pakistan, which may also include the members of the committee for adjudication of the matter. I will simply say on this thing that this is...
Sir, on your right side, but not as much right as previously.
Yes, my lord.
Over here. Question, so your associates can note this. This power that Section 3 purports to confer on the committee with regard to examine the question and therefore act as a gateway perhaps, is this a power, or is this a judicial power, or is this an administrative/statutory power? Because 183 is ultimately a judicial power, because then it seems to me that the latter part of this section says it shall constitute a bench. That seems to imply that the power exercised by the committee is not a judicial power, but an administrative power. So can Parliament whittle down? This is the question. Please note.
Yes, it's
whittle
noticeable,
down
and
the
in fact, that is
whittle down
exactly,
power-
that will be exactly my proposition.
Please, here is Lordship.
सवाल तो सुन लें. Can the Parliament whittle down the judicial power under 184(3) by providing that this committee will act as a gateway and block out in exercise of administrative power anything that the committee feels, 3 judges, not the whole of the Supreme Court, but 3 judges, senior most respectable judges, but in the end just 3 judges, block out any case that they, in exercise of administrative power, they will deprive the Supreme Court from exercising judicial power. So you kindly note the question and you address it at an
And I will go even further than that,
And also a supplementary question connected to this. Earlier, the justice solely had this power. So there was a likelihood that the outcome of the cases could also have been influenced by the constitution of the bench. So that eroded the independence of judiciary. If this argument is accepted, then the earlier traditional model would be acceptable to you, that one person can actually control the outcomes of the cases by constitution of benches, and this probably was the mischief that the Parliament wanted to address.
If I may add, there is a judgment of this court and the judicial pronouncement as to what procedure would be followed by the Chief Justice to invoke jurisdiction of this court under Article 183. And it says where a bench, 3-member bench, 2-member bench, but a bench comes to the conclusion that there is a matter of public importance affecting fundamental rights, they may recommend to the Honorable Chief Justice that a bench be constituted. And the Honorable Chief Justice, after seeing the reasons that the bench has assigned for recommending, he may or may not, but at least he would record reasons why he thinks he disagrees with the recommendations, or thereafter he can proceed. And so there is a judicial pronouncement on that already in place.
In fact,
Raja Sahib, I'm sorry, since
may I say,
Honorable Chief Justice has said that we can only ask questions and not for you to respond immediately. So let me, with all due respect, ask a supplemental to what the supplemental put to you by my learned brother, colleague Justice Atar Minallah. It seems to me that the power to constitute a bench, which is the subject matter of Section 2, constituting a bench does not block the exercise of judicial power. It simply determines which is the bench that is to exercise judicial power.
Yeah.
But my question to you is that Section 3 seems to go beyond that. Section 3 is separate from Section 2. It actually blocks, it confers on the 3-member committee exercising administrative powers to actually block the exercise of judicial powers. It's not a question of constitution of benches. They can say, sorry, out, nothing further, matter ends. The question is this, so this is not a question of composition of benches, that is power universally on them in terms of Section 2. The question here, it seems to me, is the very blocking of the judicial power itself. Can Parliament do that? Question is maybe noted.
And
you don't have to answer.
No, I'm not
please
answering.
carry on.
I'm not answering.
The Honorable Chief Justice said you carry on with your submissions. Just note the question.
This thing. I may add one thing to it. It also deprives me of my right, which they have said that they are passing this thing under Article 10A of the Constitution. Here, if Section 3 is there, I am being condemned not being heard.
Who is
the
that?
party is not being
Please,
heard.
who is when you're using the word I? Who is the I here?
Litigant? The litigant. Because
एक second, sir. Tahammul. The litigant. That leads me to another question. Your petitioners, do they have an interest in the matter, or they've come purely as a matter of public interest?
No, I am looking at Section 3.
No, I'm not talking that. I'm not asking a question of the petitioners. Do they have an interest in any case why they brought this challenge, or they brought it in the public interest? What is the answer?
Answer to that is that it's a public interest.
You have no personal interest in the matter, you or your client.
I have no personal interest.
You meaning your client.
But let me say this thing.
No, I just want to know an answer to that.
Myself and Mr. Siddiqui, we are doing this as pro bono. We are doing it because we want to know,
I don't know who you're speaking for. Are you speaking for counsel? Are you speaking for petitioners?
I am speaking for the petitioner, and I'm saying this thing that we brought this petition in the interest.
You got the answer. Now please proceed. I've got the answer.
In the interest that the law should take its course. The constitution must be upheld. And I'm also saying that I'm sure with such preliminaries sitting there, the whole object is that, first of all, the independence of the judiciary should not be in any manner smeared by any other institution. And secondly,
Khwaja Sahab, please. We are not going to platitudes.
I will not make a political speech.
Khwaja Sahab,
I'll refrain from that.
Let us proceed with
Khwaja
that.
Sahab,
Yes, sir.
Khwaja Sahab, just a confusion which you can answer later. So what you are saying is that the untrammeled, unaccountable powers of the Chief Justice exclusively to decide constitution of benches, you were satisfied with that, and that fulfilled the conditions of Article 10A. But if it is done by the Chief Justice and two senior judges, you have an objection to that. That's your proposition.
I think your Lordship is possibly not. I've not been able to explain. Section 2 stands on its own footing, and I have objection on that. Section 3 is a totally different thing. It takes away the powers of this honorable court. Instead of Section 3 is a totally different thing. It takes away the powers of this honorable court. Instead of
Is it your argument?
Let us clarify.
Is it your argument
takes
that
away
Section 3 affects the judicial powers of this court?
Yes, sir.
Curtails judicial powers of this court, because this court means the Chief Justice and all judges. So it confines that power to 3 judges and not to the judges of the Supreme Court.
That's not mine. 2 and 3 have to be read independently and separate.
Now, please.
There are 2 in exercise of administrative powers.
Yes, sir.
I'm trying to make your life easy, but if you don't want it to be made easy, that's fine by me. Please don't interrupt. I requested you, please keep noting the queries. Naturally, you have a chain of thought, you have submissions. We don't want you to get, I can appreciate your position, so many judges, so many questions, which one do you answer? And then your argument is lost sight of and you go somewhere else. So please persevere with your thing, keep noting the questions, and you can address them. So I'm trying to make your life easy, unless you don't want it to be made easy. So proceed with your case. Note the question, respond to it later.
To be very honest, I welcome this interruption.
Can I ask you a question? Can I ask?
Far right.
Please. What about the office of the Chief Justice after passing of this act? Don't you think that the office of the Chief Justice would become redundant? Because he would be left with no powers then.
We noted this down, and in fact, I will say that as if this law goes through, the powers will be whittled down, but we will explain it in something. And this has been held in many places, that the Chief Justice has the power to form the benches, is the rooster, and I can go back years and years when a chain of judgments have come in, and the latest one is, of course, 2000.
ऐसा फिर आप आंसर करने
All right,
बैठ गए।
I will continue. Let me
आप नोट
continue.
कर लें या बाद में कर लें।
Let me continue then.
Mr. Khwaja, I will add it.
Then is a question.
Mr. Khwaja,
Yes, sir.
right side.
Right side. Okay.
I will add to it. Whether the power of the Supreme Court has been curtailed or the power of the Chief Justice has been.
I
This is the moot question.
The answer to that is that it's been noted, sir. It's noted, and I will only say this thing, that Supreme Court, what is Supreme Court? Supreme Court is Chief Justice and so many other judges.
Fajr will be sitting here till 12 o'clock.
I know that, sir.
So आप जरा अपना आर्गुमेंट करें।
But,
अभी तो हम सेक्शन
let's
3 पे
go-
पहुंचे।
let me, on section 3, I will only say this thing, that this certainly is, the parliament has taken away the power not only from the Supreme Court and the judges, but also it has condemned me unheard and violated the provisions of Article 10A, which provides for a fair trial. Because I will file a petition, I've not even heard, and 3 judges or about 2 judges, they will decide on an administrative side, and I'll be out. So the question of 184(3) will become totally redundant. This is my point. Therefore, to that extent, section 3 is. Then next is 4. Interpretation of the Constitution. In the matters where interpretation of the constitutional provision is involved, committee shall constitute a bench comprising not less than 5 judges of the Supreme Court. Well, I will.
Do you object? First say I object to this provision, or you endorse it?
I will say this, sir, that in the matters of interpretation of the Constitution, when you are, all the judges are competent to interpret the Constitution. Limiting it to 5 or limiting it to 3 or why not 7? Why not 6?
Please.
I object to this thing that this is a limitation.
No, it's not a limitation. It says not less than. It could be a full court like the present court. So are you just safe? Is this ultra vires the Constitution, Section 4? Say something. We should note it.
On this, I will only say this thing, that putting a clause that the bench should be not less than 5, that possibly is expressing, shall I say, not confidence in less than 5 judges. Because this is very strange, because all judges are equal. Your Lordship is the first amongst the equal, but every other judge of the Supreme Court has the same powers and the same acumen. So by saying this thing, not less than 5, then there's a question of appeal, and which is a very relevant point.
Khwaja Sahab, as I understand your earlier proposition, you are satisfied that the Chief Justice in the previous model, being the master of the roster, had untrammeled power to constitute a bench of 3 members, and you were satisfied with that.
I have noted this thing.
Yes.
Your Lordship did not. I would not be able to explain. It's my shortcoming.
Explain later.
On the question of benches, I have stated with this thing that this power should be exercised by the full court, not by the parliament. How the benches are to be formed.
In a nutshell, you are suggesting that the powers as master of the roster in the Chief Justice were also unconstitutional.
No, sir.
This is your suggestion.
No, sir. I'm saying this thing that another 1980 rules, that power had been given. If all of you sitting together feel that under 191 that this should be changed, then it is your functions. It is not the function of the parliament.
Okay, now let's proceed. We'll ask.
I'll argue on that. That is the point which needs consideration. 5 is appeal. Yes, Manisha.
On section 4.
On 4.
If memory serves me right, section 4, what is the equivalent of section 4, is part of the Indian Constitution as an article of that Constitution. It was a part of the 1956 Constitution as an article of that Constitution. Now, question is that when the framers of the present Constitution had before them this model
where this very power was conferred on the Supreme Court in the way that what in India they are called constitution benches. The question is this: that model, that aspect was not accepted by the framers of the present constitution, because they had a model both from India and from Pakistan itself. So the question is this: if that was not accepted, does this not require constitutional amendments? Can Parliament do something which the framers of the Constitution deliberately seem to have left out, despite the earlier models? Can Parliament then, in exercise of sub-constitutional jurisdiction, namely legislative competence, do something that was earlier part of the Constitution? This is the question. Please note.
Yeah, it's noted, sir, and I may add on to this.
साहब मैं एक सवाल पूछ लूं आपसे, अगर उसी में डाल दें आप लिस्ट में अपनी।
जी
मैं इधर हूँ जी।
जी सर।
भाई बस सिर्फ सिंपल सा आपकी जो समझ आई है मुझे आपकी कि ये सारा कानून अगर यही सारा को फुल कोर्ट बैठ के बना ले तो सब ठीक है।
नहीं सर,
सुन लीजिए सवाल तो सुन लें।
जी जी।
कि 17 जज बैठ के ये सब कुछ बना ले तो ठीक है, पार्लियामेंट ये सारी चीज बना दे तो गलत है। ये आपकी बहस है ना सारी?
नहीं नहीं सर, ऐसे नहीं है।
आपने यही कहा, आपने कहा ये सारी चीजें करो, लेकिन
नहीं सर ऐसे नहीं,
सुप्रीम कोर्ट
नहीं सर ऐसे नहीं है।
चलिए बस नोट कर लीजिए।
मैं नोट कर लिए, जब सुप्रीम कोर्ट एक
आप जवाब ना दीजिए ना, बाद में
मैं बाद में जवाब देता हूं,
ठीक है, अदरवाइज तो आप आपकी मुश्किल काम हो
नहीं, मैं आई एम क्वाइट आई हैव अ वेरी
नहीं, आगे बढ़ते हैं।
I have worked with all of you, sir.
आगे बढ़िए।
I have no problems.
हजूर आगे बढ़िए, आगे बढ़िए।
If I may,
कोई
Khwaja sir,
problem नहीं है. I understand what Shah Sahab is suggesting and saying, and he has mentioned this in many other cases. Yes, ma'am.
If I may ask a question as a supplemental to the question that my learned brother, my learned colleague has asked. Independence of the judiciary is a recognized fundamental right.
Yes, ma'am.
So the question, surely, this is the question to you, surely the question of what the court can itself do to regulate its own practice and procedure is now encased in independence of the judiciary, and can Parliament intrude upon, with all due respect to Parliament, they have their legislative competence, the Constitution is supreme, that is what is paramount, that is what is there. Can Parliament, in professed exercise of a legislative competence under Article 191, trample upon, I'm using this word a bit deliberately, I don't intend to show any disrespect to Parliament, but can it encroach upon or intrude upon something that would affect independence of the judiciary, something that relates to practice and procedure, which the court may or may not do, but can do for itself?
Yes.
Can Parliament do that? In other words, when Article 191, this is part of that question, starts with subject to the Constitution, the law part of it is also being subject to the Constitution, and the Constitution says independence of judiciary is a fundamental right. Can Parliament directly or indirectly take away a fundamental right?
Not through ordinary legislation.
आप नोट कर लें।
Not through ordinary legislation.
If I will really request my colleagues that they are making, including myself, are making your life impossible. No, please, no, you are very fine.
I'm
no.
learning.
No, we are not here to teach you anything. You are here to help us. Now, please, we're not even reading the act, and we are getting bogged down into details. Let us go through it, formulate your contentions. We will bombard you with 100 questions. You respond to them later. You respond to everything, then the matter gets lost. Again, we are stuck with section. We are not even making progress. Please continue in your way.
आगे बढ़ते हैं. Let me say this.
Mr. Khwaja,
Khwaja sahab, section 5 से आगे पढ़ लीजिए.
another question with regard to appeal. आप देखें, हमारे पास already एक dictator का ordinance था, Law Reform Ordinance 1972. उसके तहत Article 199 के लिए appeal provide की गई before 2 member benches. We are following it. क्या वो जो डिक्टेटर का था वो दुरुस्त है और पार्लियामेंट अपील का राइट नहीं दे सकती? वहाँ तो अपील का राइट दिया है, सेम प्रोविजन कॉन्स्टिट्यूशन, आर्टिकल 199, here आर्टिकल 183, 84(3). तो ये क्या दोनों में
Sir,
अगर ये गलत है तो फिर वो भी गलत है।
it is noted. We'll answer this thing that what Parliament can do and what Parliament can do many things. My Lord has said so, but
ऐसा-
there is a procedure
ऐसा-
provided. We'll answer that.
भाई साहब अभी जवाब की जरूरत नहीं है, आप प्लीज एक्ट
I will
कर
not answer
लीजिए,
it.
पहले एक्ट को खत्म कर
Section 5 से आप आगे बढ़ लीजिए, ख्वाजा साहब.
Khwaja Sahab,
You have collected 100 questions.
Just here. The law reforms ordinance of
How you will
1972, this is the question to you, regulated a right of appeal within the High Court itself, an intra-court appeal. Was there ever a clause on the jurisdiction and on the legislative competence in relation to jurisdiction and powers of the High Court in the same manner as it is in the Supreme Court? As I read it, the clock is there only in respect of the Supreme Court. Law reforms ordinance didn't do anything with the Supreme Court. It only affected intra-court appeals within the High Court, both in the concurrent list, which is now no longer there, and also the clock was only in relation to Supreme Court. Question: is therefore the law reforms ordinance of 1972 a parallel valid example which relates only to the High Courts, a valid parallel example in relation to what Parliament seeks now to do in the 2023 Act? This is the question. With relation to the Supreme Court, where there is apparently a clock.
Mr. Noted, sir. And appreciate. Section 5. An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of Article 184 of the Constitution to a larger bench of the Supreme Court, and such appeal shall, within a period not exceeding 14 days, be fixed for hearing. And second part, the right of appeal under subsection 1 shall also be available to an aggrieved person against whom an order has been made under Clause 3 of Article 184 of the Constitution prior to the commencement of this Act, provided that the appeal under this subsection shall be filed within 30 days of the commencement of this Act. I'm not going to analyze it. I have my serious objection on this, and I will.
What you have to do, you're saying I'm not going to do it. You have challenged the law, you have to do, you have to challenge it.
Appeal shall lie within 30 days.
We've read the English of it. What's wrong with it? Tell us that.
My Lord, as far as Section 5 is concerned,
Is it good? Is it bad? First tell us that.
Well, it says that appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of 184. May I respectfully submit that if an appeal is provided against a decision under 184.3, then why is this not they included in Clause 2? Whereby my 184.3 application will be disposed of.
The way I was taught law was not the council asked questions from the bench. It was the bench would ask questions. Are you supporting this provision or not? First say, yes, I am, no, I am not. These are my reasons.
My Lord, I have a reservation on this.
You may have reservations. Tell us what's unconstitutional about it.
Then let me explain it to them, because if I start explaining it at this stage, it will take your time. But I will say this thing, that this Section 5 should have also, this right of appeal should also have been given in Section 2.
Should is different from ultra vires the Constitution.
It ought to have been given.
What then? You go and move a bill in Parliament. We are saying, are you opposed to Section 5? Give us legal reasonings, or you say it's okay. अब उनसे आप पूछेंगे
You have done this.
नहीं ये नहीं आप जवाब दीजिए ना आपने पिटिशन लाए this is not fair.
इसमें to make it more simple, you don't want your client to have a right of appeal.
No, sir,
If I say it's unconstitutional, it's constitutional, you're not saying anything, you just... यहाँ कोई discussion होता है, sorry, not on. This is your job in office.
My Lord, may I say this thing that we divided the...
Please answer the question, is this constitutional or unconstitutional? I can't hear you.
वायरिस तो बताइए ना, वायरिस क्या है?
है अनकॉन्स्टिट्यूशनल आपके जहन में और नहीं है?
Unconstitutional.
Well, my personal opinion is this, sir, that this Section 5 goes beyond the powers which were there with the Parliament.
So now formulate a contention on that. Please formulate a contention.
For the simple reason, my lord, if an appeal is to be provided, it's a substantive right. There has to be a constitutional amendment to provide an appeal under Section 184(3).
Okay.
And this appeal through this act, an ordinary law, cannot provide.
I can't seem to reconcile your, which I appear to me to be contradictory submissions. Please let me finish. Please let me finish.
Yes, ma'am.
On the one hand, you are saying, where will I go? Where will I go? Here, the Parliament has given you a right. You say it's unconstitutional. So please don't make contradictory contentions.
I'm only saying this thing, that it's a good thing that the right of appeal be given, but the manner in which it has to be given.
Please take it.
I'm saying this thing, that this one, the right of appeal given in this manner by an ordinary law.
We will not strike it down because of manner. You have to show us ultra vires the Constitution.
It is unconstitutional, sir.
But saying so, no argument.
Our argument is this, that 184(3) is a substantive provision of the Constitution. If
you are happy with no appeal.
If a right of appeal has to be given, there has to be a constitutional amendment.
Okay, point taken. Move ahead.
I just have a question to you with regard to Section 5 from what you have just said. Kindly read it again.
An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of Article 184 of the Constitution.
Just kindly stop. So this order, the question to you is, has two parts. So the first part is, this question, this order, which is now made appealable, is it a judicial order or is it administrative type of order? And if it is a judicial order, then how can Parliament, in exercise of a legislative competence conferred by Article 191 in relation to practice and procedure, confer a right of appeal? Because if I may, and this is the, I apologize, my question has three parts. Because if I may touch upon what my learned colleague, Mr. Justice Mansoor Ali Shah, said recently, that this is recently, meaning in the hearing of the case, that anything that this law does, the Supreme Court can itself do in exercise of rule-making power. Question therefore is, can Supreme Court confer a right of appeal in exercise of rule-making power against a judicial order under 184(3)? If the answer is no, then it seems to me logically that Parliament also can't do it, because the two things are parallel. Therefore, question, is it therefore unconstitutional?
Unconstitutional.
You don't have to give an answer.
If the right of appeal had to be given through an amendment.
Noted down.
Yes, next is right to appoint.
आप चाहें तो आप हमें लिखकर तहरीरी तौर पे भी जवाब दे दीजिएगा, ठीक है? अगर आप आगे अपना आर्गुमेंट चलाते रहें, जी आगे बढ़ते हैं। 6 को पढ़िए, 6
है जी, right to appoint counsel of choice for filing a review application under Article 188 of the Constitution. A party shall have the right to appoint counsel of its choice. I don't object. I personally don't object.
Personally की बात कोई नहीं है।
I'm not objecting to this because I feel that
okay, it's okay. Chaliye, let's get on with it. Section 6 is okay.
Okay. Application for fixation of urgent matters, application pleading urgency or seeking interim relief filed in a cause, appeal or matter shall be fixed for it. My objection of this is again that this is a function of the Supreme Court itself, because this relates to the
Please
procedure.
tell us, is it ultra vires the Constitution?
It's ultra vires.
Thank you.
I just have a question to you on this, on Section 7. Now, Section 7 really relates to what is regarded as the nitty-gritty of procedural law. I mean, this is really going, you say, in a civil court into the very depths of CPC or
the way we in the Sindh High Court have original side into the Sindh Chief Court rules original side.
Yes.
The question therefore is this: the legislative competence under Article 191, if it allows Parliament to go into so much depth into the very nitty-gritty of procedure of the court, then surely Parliament has an untrammeled power to regulate the court itself. The power to regulate, if I may adapt, is the power to destroy. Does this not effectively destroy the independence of the judiciary?
This was my very first point which I said,
Sir,
that the functions of the Supreme Court have virtually been taken over.
Is this not contrary to the fundamental principle of the Constitution, trichotomy of powers? So where the legislative organ is intruding upon the nitty-gritty and the procedural aspects which have specifically been left to the Supreme Court under Article 191, is it not an intrusion in the boundaries created by the trichotomy of powers?
That is why I say 7 is ultra-wise.
Ismail Khwaja Sahab,
Yes, sir.
I think there's a very crucial and important question. The jurisprudence of this court, developed till today, has only looked at one aspect of independence of judiciary, that is freedom from external factors. But there are two other extremely or probably more important factors that affect independence of judiciary, and that is internal independence and institutional independence. What the Parliament appears to be looking at is the aspect of internal and institutional independence, where probably in the perception of the public or the Parliament, those powers exercised over the years by the Chief Justice under the rules, they actually eroded the internal and institutional independence. So, when we talk about independence of judiciary, these two aspects that have been ignored till today, they are probably more important.
Sir, we will certainly answer your lordship. Sir.
Please, one question also.
Since we have just one section, can we just finish reading it?
Sir, if I may have a supplemental on
Yes,
what
ma'am.
my learned colleague has said. Is it possible, is it constitutionally possible that if at all, and speaking for myself and with very great respect, perhaps I do not subscribe to that view that has been expressed, but I ask a supplemental question on it. Is it constitutionally conceivable that if there is such a concern about the internal independence of the judiciary, that the solution is to put the power in the hands of Parliament? Would that not violate separation of powers? Tomorrow, what is there to prevent, and this is a question to you, what is there to prevent Parliament from making a so-called law relating to practice and procedure and provide the federal government is hereby conferred powers to make rules and, for the practice and procedure of the court? There is no end to it. If at all there is any trouble, and as I say, I have very deep regard and respect for my learned colleague, all of them, but in particular Justice Athar, is this really the solution? That is, okay, here's a problem internally to the, would that not violate, well, I mean, no, as I say, it's constitutional, is it even conceivable? I mean, where would that
with due respect, my lord, this is a bit...
ख्वाजा साहब ये एक बात सुनिएगा, इधर एक क्वेश्चन
आप इसको खत्म तो कर लेना सेक्शन को, आप सॉरी टू से
आर्टिकल 8 खत्म कर लो।
आप पढ़ ही नहीं रहे हैं।
अभी पढ़ लेता हूँ सर, ये सवाल बड़े पर्टिनेंट,
आप हर चीज आप नोट कर लेना।
नोट कर भी दिया मैंने सर, कर ये कहा मैंने शुरू में ये कहा था।
आप शुरू में क्या कह रहे हैं, आप आखिरी सेक्शन पढ़ लें।
मैंने शुरू में ये कहा था, आपने शरीफ साहब, और जो ये आप कह रहे हैं कि जो इंटरनल वर्किंग ऑफ द सुप्रीम कोर्ट है उसमें किसी और का दखल नहीं होना चाहिए। یہ اگر یہ دخل اندازی ہوگی تو پھر یہ سپریم کورٹ نہیں رہے گا.
ایک بات اور نوٹ کر لیجئے گا, آپ نے کہا سیکشن 5 جو اپیل ہے وہ الٹرا وائرس ہے ٹو دی کانسٹیٹیوشن, مگر ایٹ دی سیم ٹائم while you are reading section 6 it is right of review. You say that you have no objection to it. Why? Because the choice has been given to appoint the council of his own choice. No, when the law is totally ultra virus, then how you can say that section 6 is okay with you?
No, my own view was that at times we have the rules are there that if a lawyer says that I'm ill or I'm out of the country or I'm not well, you do allow in review.
You are declaring right of appeal ultra virus and right of review intra virus.
No, what I'm saying is that
according to your own arguments.
The question is that you cannot provide a right of appeal.
But you can provide the right of review.
Under 184.3, if 184.3 right of appeal is given in accordance with the constitution, then as far.
خواہد صاحب پھر آپ اپنے لیے آپ ذرا سن تو لیجئے نا, آپ یہ سوال جو ہیں ذرا آپ سن تو لیجئے نا, یہ جو سوال ہیں ان کو اتنے ایزلی برش اسائڈ نہ کیجئے, ذرا سنیے پلیز. آپ غور و فکر سے, ہم نہیں چاہتے ہیں کہ آپ فی البدی کوئی جواب دے دیں جو پھر آپ کے لیے مشکل ہو. ہم اسی لیے آپ کو کہہ رہے ہیں ہر سوال نوٹ کر لیجئے, آرام سے جواب دے دیجئے. آپ خود اپنے لیے مشکلات کھڑی کر رہے ہیں, ہر سوال کے جواب دینے لگتے ہیں. ہم تو صرف آپ سے سوال پوچھیں, نوٹ کر لیجئے گا آگے چل کر کے, ٹھیک ہے. ہم دیکھیں, ہم ایک دوسرے سے ادھر بحث کرنے کے لیے نہیں بیٹھے ہیں. ہم آپ کے سننے کا, آپ نے چیلنج کیا ہے ایک قانون کو کہ یہ غیر آئینی ہے. یہ بہت فرق ہوتا ہے کہ ایک کہنے کے لیے کہ مجھے یہ قانون پسند نہیں ہے. ذرا آپ پلیز نہ خاموش رہیے 2 منٹ, ہم بھی آپ کو سن لیتے ہیں خاموشی سے, آپ بھی تھوڑا سا تحمل کا اظہار کر لیں. تو یہ بہت سے قانون ہیں شاید مجھے بھی نہیں ذاتی طور پہ پسند ہوں, ٹھیک ہے, مگر میں نے حلف اٹھایا ہے کہ میں آئین اور قانون پہ عمل کروں گا, تاکہ انلیس کہ میں اس کو سٹرائک ڈاؤن کر لوں قانون کو, وہ ایک الگ بات ہے کہ یہ الٹرا وائریز دا کانسٹیٹیوشن ہے. تو آپ نے کہا مائی پرسنل اوپینین ڈزنٹ میٹر, تو آپ کی بھی پرسنل اوپینین کی کوئی حیثیت نہیں ہے. آپ کو آئینی جواب ہر چیز کا دینا ہے کہ یہ اس شک آپ نے ایک بحث میں ایک آرٹیکل آئین کا آپ نے ریفر نہیں کیا کہ یہ کس آرٹیکل کے تصادم میں ہے. دوسری بات آپ نے جو بالکل نظر انداز کر رکھی ہے, یہ ہم نے سیو موٹو کیس نہیں لیا. اگر ہمارے حقوق پہ اتنا زبردست وار پارلیمنٹ نے کیا ہوتا تو ہم نے بہت سارے کیسز میں ہم نے خود بھی اٹھا لیے کیسز کو. یہ تو آپ ہمارے طرح سے ڈیفینڈر کے طور پہ رونما ہوئے ہیں اور کہا یہ جنگ میری ہے, ٹھیک ہے. یہ صرف پروسیجر میٹر, کس میں کسی کی رائٹ غائب نہیں ہو رہی, کسی کی ایک رائٹ کنفر ہو رہی ہے, کسی کی رائٹ چھینی نہیں جا رہی ہے. تو برائے کرم آرٹیکل 184(3) کے دائرے میں رہ کر آپ نے, جس کا آپ نے ایک لفظ نہیں ذکر کیا ہے, وہ کہتا ہے any matter of public importance. چلیں جی, پبلک امپورٹنس تو ایک وہ ہے ڈیبیٹیبل کوشچن, ہم یہ کہوں گا آپ کہیں گے وہ ہے, مگر فار دا انفورسمنٹ آف فنڈامنٹل رائٹس, ٹھیک ہے, یہ اس کے پریمبل میں انہوں نے فنڈامنٹل رائٹس کا تذکرہ کر دیا ہے, جس کو آپ نے بس نظر انداز کر دیا. ٹھیک ہے, یہ بہت اچھی بات ہے کہ آپ میرے حقوق کے لیے جنگ لڑ رہے ہیں, مگر یہ میرے حقوق اور آپ کے حقوق کی نہیں بات ہے, یہ آئین کی بات ہے اور لوگوں کے حقوق کی بات ہے. یہ آرٹیکل 10(a) کا حوالہ دیتا ہے, آرٹیکل 25 کا دیتا ہے. تو آپ کھڑے ہو کر اپنی رائے آپ کالم لکھیے اخبار میں, ہمیں صرف اور صرف آئینی بحث کیجئے کہ یہ 184(3) کا جو ہم نے جو پاور آج استعمال کر رہے ہیں وہ یہ ہم اپیلیٹ پاور نہیں استعمال کر رہے ہیں, نہ کوئی ہائی کورٹ نے کوئی فیصلہ کیا ہے جو ہم بیٹھے ہوئے ہیں ایز آف رائٹ اپیل سن رہے ہیں, پٹیشن فار لیو ٹو اپیل سن رہے ہیں. ہم اوریجنل جوریسڈکشن میں بیٹھ گئے, اس کی بہت محدود چیزیں, مجھے بہت سی چیزیں قانون میں شاید ناپسند ہوں, میں یہ نہیں کہہ سکتا ہوں کہ جی اس کو ایسا کر لیں کہ ایسا نہیں کرنا چاہیے تھا. تو آپ برائے کرم آپ نے ایک انفورسمنٹ آف فنڈامنٹل رائٹ سے تو آپ نے کچھ بحث ہی نہیں کی ابھی. ذرا آپ پلیز, اور ہر بات کو آپ نوٹ کیجئے. اگر آپ بس آپ ہر چیز کو جواب دینے لگتے ہیں بغیر سوچئے, ہر بات کی بہت اہمیت ہوتی ہے. میرے کولیگز کی جو سوال ہیں وہ بڑے اچھے سوال ہیں, ذرا غور و فکر چاہتے ہیں اور پھر جواب دیتے ہیں. اگر آپ جلدی سے کریں گے پھر آپ کو دوبارہ موقع نہیں دیں گے, پھر کہیں گے اب مجھے اچھا جواب آ گیا. پھر اب آپ پلیز 184(3) کے تقاضے بھی پورے کر لیں.
آپ کے بالکل 184(3) کے تقاضے
میرا ایک سوال بھی نوٹ کیجئے. KP on the border پلیز. آپ کیا سوچتے ہیں دس ایکٹ ہیز بین پاسڈ ان دی پبلک انٹرسٹ؟ کیونکہ سیکشن 5 سب سیکشن 2 says on the contrary. It appears that to do away with some of the decisions which were passed in the previous years under Article 184(3) of the Constitution, کیونکہ commencement ان کی کر دی ہے اور اس میں کوئی limitation بھی نہیں ہے. تو یہ پبلک انٹرسٹ میں پاس ہوئے یا پرسنل انٹرسٹ میں ہوئے؟
Yes, your point is noted, sir. I will not answer now. I'll answer it later.
Mr. Khwaja, another question. Please ایک اور note کر لیں. We have two provisions in the Constitution. One is Article 191, which relates to Supreme Court, and the other is 202 of the Constitution, which relates to High Court. Same alfaz ہے, ماں سوائے وہاں پہ Supreme Court, یہاں پہ High Court. Subject to the Constitution and law. Law تو بناتی ہے پارلیمنٹ. تو آپ کے آرگومنٹ سے ہم یہ سمجھیں کہ پارلیمنٹ کو آپ لا میکنگ میں محدود کرنا چاہتے ہیں کہ آپ یہ تو کر سکتے ہیں, یہ نہیں کر سکتے, یہ رولز میں سپریم کورٹ خود کرے گی یا ہائی کورٹ خود کرے گی.
سر میں اس کا آنسر دوں گا, بالکل دوں گا. جب سبجیکٹ ٹو کانسٹیٹیوشن آ جائے گا اور جو لا آئے گا وہ آپ کو کانسٹیٹیوشن کے ساتھ رکھنا پڑے گا.
یہ بھی کہ کیا لا کے تحت کیا کر سکتے ہیں پارلیمنٹ, کیا نہیں کر سکتے.
کیا نہیں کر سکتے, یہ اس کا جواب دیں گے جی آپ کو.
Another question, where a rule has been framed under constitutional power granted to this court.
Yes, sir.
This is with reference to section 6 that you just read. You would notice that Order 26 of the Supreme Court rules does provide for all eventualities in which a review can be filed procedurally. The question is where the Supreme Court, in exercise of constitutional powers granted by the Constitution, framed rules, the Parliament can legislate and override those rules or amend those rules. That's the question. Noted. Please answer when you are answering.
Additionally, through already law or through the point is taken, sir, by already with me, and I will answer that. And I have my own views on this, that the Parliament cannot do this thing by an ordinary.
حضور آپ کے ویوز کو چھوڑ دیجئے نا, آئینی تقاضے پورے کر لیں نا.
Number 7 is application for fixation of urgent matters.
تو ہو گیا.
Application pleading urgency or seeking internal relief.
اچھا میں آپ کو ایک مفروضہ پہ چھوڑ دیتا ہوں. آپ نے درخواست دی, بہت اہم کیس ہے, ارجنٹ کیس ہے, میں نہیں لگاتا ہوں, میری مرضی. صرف جواب دے دیجئے, میری مرضی. میں 10 سال اس کیس کو نہیں لگاؤں, میری مرضی.
میں نے اس میں کچھ نہیں کہا.
میں آپ سے سوال پوچھ رہا ہوں
جی.
انہوں نے میری مرضی لے لی, شاید میں خوش نہیں ہوں اس بات سے, میری مرضی میں نہ لگاؤں کیس. ایک بہت اہم کیس ہے, اس میں انہوں نے لکھ دیا 14 دن میں آپ اس کا, بھئی صرف اس کو لگا دیں, کوئی فیصلہ تو نہ کریں. تو میں کہوں گا میری مرضی. میں جو یہ ٹیکس پیئر پیسے دے رہے ہیں اس عدالت کو, جو ہمارا بجٹ ہے, میری مرضی پہ چلے گا. اس پہ سوال کا جواب دیجئے. میں نہیں لگاتا ہوں. آپ کا یہ کیس آپ نے فائل کیا, ٹھیک ہے, میں نہیں لگاتا اس کو. آپ کیا کر لو گے؟ کچھ بھی نہیں کر سکتے ہیں. آپ کے ہاتھ پیر کٹے ہوئے ہیں. انہوں نے ہم پہ بھی, میرے کولیگ نے ایک بات کی انٹرنل اور انسٹیٹیوشنل انڈیپینڈنس کی. میں 2 باتوں کا اضافہ بھی کرنا چاہتا ہوں, اور وہ ہے, اور وہ آئین سے پہلے بھی ہمارے پاس تھا, وہ ہمیں اوپر والے کو حساب دینا ہے, ٹھیک ہے. اکاؤنٹیبلٹی اینڈ ٹرانسپیرنسی. آپ ہمیں ٹوٹلی ان اکاؤنٹیبل بنانا چاہتے ہیں چیف جسٹس کو. میں تو بہت خوش ہوں گا, کیونکہ یہ قانون اگر سسٹین ہو جاتا ہے تو میرے پار تو کم ہو گئے باقی چیزوں کو چھوڑ کر کے, ٹھیک ہے. اس قانون کو اڑا دیں, میں طاقتور بن جاتا ہوں. یہ بھی ہے, میں اکاؤنٹیبل ہوں. یہ بھی ایک سوال ہے. آپ کا آئین جو شروع ہوتا ہے وہ سپریم کورٹ کی انڈیپینڈنس سے نہیں شروع ہوتا ہے, وہ اللہ تعالیٰ کے بابرکت نام سے شروع ہوتا ہے, ٹھیک ہے. اور ہم سب, ایوری ون ٹو ایکسرسائز پاز ایز اے سیکرڈ ٹرسٹ. آئین میں آرٹیکل 227 بھی دی گئی ہے کہ شرعی اصولوں پہ اگر آپ کے کوئی بھی قانون تصادم کرے تو وہ پریویل کریں گے. تو برائے کرم ایک انڈیپینڈنس آف دا جوڈیشری سے یہ مطلب نہیں کہ اگر انڈیپینڈنس آف جوڈیشری سے میں کسی کا دروازہ بند کر رہا ہوں تو وہ تو میں بالکل مجھے استعمال نہیں کرنا چاہیے. تو آپ یہ پٹیشن لاتے, سپوز میں چیف جسٹس ہوتا میں اس کو لگاتے ہی نہیں, تو ہم یہ بے کیس ہی نہیں سنتے کبھی. 10 سال پڑا رہتا, میں مضبوط رہتا چیف جسٹس کے طور پہ, آپ خوش تھے اس بات سے. تو برائے کرم آپ یہ جو بار بات کرتے ہیں نا, میری ذائع, میری مرضی, میری نہیں ہے جب میں چیف جسٹس ہوں, تو برائے کرم ہم وکیلوں کو بہت ہی قدر کرتے ہیں, مگر میرا کا لفظ نہ استعمال کیجئے. انگریزی میں کہتے ہیں me, myself and I are the 3 most useless words in the English language. اس کا میں اردو میں ترجمہ نہیں کر سکتا ہوں, شاید آپ بہتر کر سکیں گے. براہ کرم آئین کا حوالے دے دیجئے کسی چیز کے متعلق کہ یہ آئین کے تصادم ہے, وہ آئین سے تصادم رکھتا ہے, یہ شک کے آئین سے تصادم. ابھی تک میں نے آپ سے وہ ایک لفظ نہیں سنا ہے اس پہ. شکریہ.
میں نے تو 3-4 جگہ کہہ دیا ہے کہ جہاں پہ 184(3) میں آپ اپیل کا رائٹ دے رہے ہیں تھرو دس آرڈنری لا, یہ ہو نہیں سکتا, بیکاز دس کین اونلی بی ڈن بائی اے کانسٹیٹیوشنل امینڈمنٹ.
یہ لفظ لکھا ہے اگریوڈ پرسن, ٹھیک ہے. اب دیکھیے, اب ایک مفہوم تو یہ نکلتا ہے 184(3) کا کہ آپ ایسے معاملوں میں نہ الجھائیں اپنے آپ کو جو انفرادی نوعیت کے ہوں.
اگریڈ سر.
ذرا اگریڈ, آپ سے اگری کریں یا نہ کریں, میں ذرا بات کر لوں انفرادی نوعیت کی. اگر ہم انفرادی نوعیت کے کیسز فیصلہ کرنے لگیں تو وہ بیچارہ کہاں جائے گا. میں آپ کو مثال دے دیتا ہوں. ریکوڈک کا کیس چلا, دونوں کیس فیصلہ ہو گئے تو میں اس پہ بات کر سکتا ہوں. ریکوڈک کا کیس آ گیا, ٹھیک ہے, سپریم کورٹ نے 184(3) میں ایگریمنٹ اڑا دیا. ملک کو, سپریم کورٹ کو نہیں, ملک کو $6.5 بلین کی ڈز لگی. ہم نے کون سا جورسڈکشن استعمال کیا؟ ہم نے ایڈوائزری جورسڈکشن استعمال کیا. اگر ہمارے پاس یہ جورسڈکشن ہوتا, میں نہیں کہہ رہا ہوں فیصلے اچھے تھے برے تھے, میں صرف اس پہ تبصرہ کر رہا ہوں, ٹھیک ہے. اگر ہمارے پاس جورسڈکشن ہوتا, ہم وہ جورسڈکشن استعمال کر رہے تھے. اب ہم نے ایڈوائزری جورسڈکشن سے معاملوں کو.
اسلام آباد سے عام خبر سے آپ کو آگاہ کریں. سنیاڑی, میرا بیری اور چونترا میں رقبہ